Every day we share personal details through our phones, messages, photos, locations, often without thinking twice. But what happens to all that data? It's valuable, and tech companies must protect it. When they fail, regulators step in with hefty fines to enforce privacy laws and protect our rights. These fines aren't just about money. They're about holding powerful companies accountable. For us, they're proof that our privacy matters and that someone is watching out for us. The legal battles that follow help clarify and strengthen privacy laws for everyone. WhatsApp's recent fight over a massive fine is a prime example of this ongoing struggle. Understanding this case shows how digital rules are made and why they matter to you. Let's break down what happened, who was involved, and why it affects your digital safety. In 2021, WhatsApp, owned by Meta, was hit with a $225 million fine by Ireland's privacy regulator. The reason? WhatsApp wasn't clear enough about how it collected and shared users' personal data, especially with Meta. This violated Europe's strict privacy law, the GDPR, which demands transparency. The investigation began after complaints that WhatsApp's privacy policy was too confusing. Ireland's regulator, the DPC, leads on these cases because many tech giants have their EU headquarters there. The fine was one of the largest ever under the GDPR, a clear message to the industry. WhatsApp disagreed, arguing their policies were clear and the penalty was excessive. This set the stage for a major legal battle over how privacy rules are enforced. The case wasn't just about money, it was about the principles behind data protection. WhatsApp decided to fight the fine in court, challenging the power of regulators. Two main players enforce privacy in Europe: Ireland's Data Protection Commission, DPC, and the European Data Protection Board, EDPB. The DPC acts as the lead regulator for tech giants based in Ireland, investigating complaints and issuing fines. But the DPC doesn't work alone. The EDPB oversees all national regulators, ensuring GDPR is applied consistently across the EU. If regulators disagree on a case, the EDPB steps in to make a binding decision. This system prevents any one country from being too lenient on big tech. In WhatsApp's case, the DPC proposed a fine, but other EU regulators thought it was too low. The disagreement escalated the case to the EDPB, which made the final call. The EDPB's decision dramatically increased the fine and set a new standard for enforcement. This process shows how European cooperation is built into privacy law enforcement. The DPC investigates, but the EDPB ensures tough, unified action. This two-level system is crucial for holding global tech companies accountable. The WhatsApp case highlights how these bodies work together, and sometimes clash, over protecting your data. It's a model for how digital rights are defended across borders. The Irish DPC originally proposed a much smaller fine for WhatsApp, around $30 to $50 million. Other European regulators objected, arguing the penalty was too low for such serious violations. Their objections triggered the GDPR's dispute resolution process, sending the case to the EDPB. The EDPB took a tougher stance, ordering the DPC to raise the fine to $225 million. This move showed the EDPB's power to enforce strict, consistent penalties across the EU. WhatsApp challenged both the finding and the way the fine was increased, claiming the EDPB overstepped its authority. The heart of WhatsApp's legal appeal became whether the EDPB had the right to force a higher penalty. This question would soon be tested in Europe's highest courts. The case became a battle not just over money, but over who truly controls privacy enforcement in Europe. The outcome would set a precedent for all future tech investigations. The stakes were high for both regulators and the entire tech industry. WhatsApp didn't just pay the fine. They launched a legal fight, targeting the EDPB's authority. They argued that the EDPB's order to increase the fine directly harmed them and should be open to challenge. The EU's General Court dismissed WhatsApp's case, saying only the DPC's final decision mattered. This shielded the EDPB from direct lawsuits by companies. WhatsApp appealed to the EU's highest court, the CJEU, arguing they should be able to challenge the EDPB's binding decisions. In February 2026, the CJEU ruled in WhatsApp's favor. Companies can sue the EDPB if its decisions directly affect them. This landmark ruling didn't erase the fine, but sent the case back to the lower court for a full hearing. Now, WhatsApp and other tech giants can challenge the EU's top privacy body in court. The decision set a new legal precedent for all future GDPR enforcement. The battle over the fine was far from over, but the rules of the game had changed. The tech industry and regulators alike were watching closely. The CJEU's decision was a turning point for privacy enforcement in Europe. For the first time, companies can directly challenge the EDPB's decisions in court, not just those of national regulators. This adds a new layer of accountability and complexity to the system. Now, tech giants have two ways to fight big fines: through national courts and by suing the EDPB at the EU level. The EDPB must now defend its decisions in court, making it more cautious and thorough. This could slow down enforcement, but it also ensures greater fairness and transparency. More companies are likely to challenge EDPB decisions, testing the strength of privacy rules. The battleground for data privacy has expanded, and regulators must be ready for tougher legal scrutiny. The outcome will shape how privacy laws are enforced for years to come. This ruling is a big win for tech companies, giving them more power to fight large fines. It could lead to longer, more complex legal battles, making it harder for regulators to collect penalties quickly. Critics worry this will slow down GDPR enforcement and weaken its deterrent effect. For users, the impact is mixed. Slower enforcement could mean less protection, but more judicial oversight ensures fairness. Regulators will need to build stronger, more defensible cases, leading to higher quality decisions. In the long run, this could create a more stable and predictable privacy landscape. When companies are finally held accountable, the decisions will be built on solid legal ground. The process may be slower, but the outcomes will be more robust. For all of us, it means privacy battles will be tougher, but also fairer. The future of digital rights in Europe is being shaped by these landmark cases. Data privacy isn't just a tech issue, it affects your daily life and your wallet. Companies use your data to profile you, influencing what ads, news, and even prices you see. Price discrimination means you could pay more for flights or hotels based on your online behavior. Without strong privacy rules, you can't know if you're getting a fair deal. Your data can also impact loans, insurance, and job opportunities. Strong privacy laws protect you from unfair judgments and financial harm. Take control, review app permissions, adjust privacy settings, and use privacy-focused tools. Protecting your data is a smart money habit and a way to demand fairness. Your privacy is power. Don't give it away lightly. The WhatsApp case isn't over. It's just the latest chapter in the fight for digital rights. The legal battles clarify how tech giants and regulators interact, shaping the future of privacy. Our digital rights require constant vigilance and strong enforcement. Understanding these issues empowers you to make smarter choices and support better policies. Your data is tied to your money, your opportunities, and your freedom. Staying informed is essential for personal security in the digital age. The fight for privacy is a fight for fairness and transparency. By paying attention, you help shape a digital world that works for everyone.